But yesterday, a case was argued by me to this ongoing court in a second appeal. आज में कुछ हम उसमें कुछ और सबमिशन करना चाहते हैं।
ऑर्डर हम ऑलरेडी कर चुके हैं, अब और कोई स्कोप
नहीं, इसीलिए हम सोचे कि हजू से पूछ ले।
पॉसिबिलिटी
अगर साइन नहीं हुआ है तो मंडे को
ऐसा नहीं होता है।
अब let's
Also, case from supplementary list item 4, content civil 915 of 2023.
I have received a written instruction from the circle officer that within 4 weeks he will demarcate the land after.
अपने पास आपका सबमिशन मेरे लिए काफी आपके प्रोटेक्शन के लिए है ना। जब आप सबमिशन करते हैं कि 4 हफ्ता में कंप्लाई कर देंगे, इंस्ट्रक्शन लेके बोलेंगे तब ना आपको एक स्कोप रहेगा बोलने का कि आप क्यों बोले थे, है ना। कंटेंट सिविल नंबर 915 of 2023. The learned counsel for the parties are present. The counsel for the opposite party submits that he has received the written instructions from the concerned circle officer that the required demarcation will be done within a period of 4 weeks.
After verifying the document.
After completing all the formalities. Pose this case on 20th March, awaiting compliance report, which should be filed by 18th of March. 20 March for supplementary list.
Item 7, content civil 1087 of 2024.
In this case, my submission before this honorable court that in terms of the order, the order has been complied with. May I read the
पहले तो आप बताइए आपका जिस्ट क्या है compliance में?
that melody case was placed before the DPC as per the order of the Supreme Court, and DPC found that his certificate of matriculation he has obtained from the unrecognized institution.
So I want to know from you, which is that circular on the basis of which you say that you will not recognize? There has to be some circular of your department कि इंटरनेट से कुछ भी डाउनलोड करके आप लगा देंगे.
No, before coming, today there is holiday in the government office, but even then from the deputy director I have obtained document. They are following the document which I have annexed from the University of Makalan Chaturvedi, where there is the list of unrecognized and the forced council and board.
हम नहीं जानते, आपको एफिडेविट फाइल करना है. और ये जो है ना, आप इंटरनेट से डाउनलोड करके डॉक्यूमेंट्स मत लगाइए, अपना सर्कुलर लगाइए. You are bound by your circulars, not by documents which is available in the internet. इंटरनेट में सब चीज सच होता है.
And another.
And one more thing, just tell me, a person who is getting a class 10 certificate or secondary certificate from Open University, can he go for higher education or he cannot go for higher education? I just want to know from you. उसको ग्रेजुएट करने का मन करेगा तो वो कर सकता है कि नहीं कर सकता, और नहीं कर सकता है तो इस ओपन यूनिवर्सिटी को बंद कर देना चाहिए.
But the Open University is of New Delhi.
Yeah, how does that make a difference? कोई फॉरेन यूनिवर्सिटी का डिग्री नहीं है कि यहाँ पे अलग से आपको रिकॉग्नाइज करना है. ओपन यूनिवर्सिटी का डिग्री है. If this person wants to become a doctor tomorrow, is there any legal bar? Yes?
There will be.
There will be.
Because
कहानी मत सुनाइए आप हमको दिखाइए कि चौकीदार बनने के लिए जो है ये ओपन यूनिवर्सिटी का क्लास 10 का सर्टिफिकेट इज ऑफ फॉर यूज. फिर तो ऐसे यूनिवर्सिटी को बंद ही कर देना चाहिए ना. लेट अस शट इट डाउन. अगर ऐसे यूनिवर्सिटी का क्लास 10 का सर्टिफिकेट चौकीदार बनने के लायक भी नहीं है तो फिर हम लोग क्यों ही इनको सर्टिफिकेट दे रहे हैं क्लास 10.
the question is not for appointment of चौकीदार, मतलब the question is the matriculation certificate.
जब आप इनका अपॉइंटमेंट किए थे, आप खोल के किए थे,
but
इनका डॉक्यूमेंट फोर्ज था नहीं था. Forgery तो नहीं था.
My lord,
Then
my lord, it was
You
subject to
have-
the verification.
what verification? Verification means what? Whether it has been issued by the competent authority or not. Verification मतलब ये नहीं है whether you will recognize this or not. Verification is what?
Verification will include also, my lord, that whether he has obtained the degree from the recognized
हमको-
institute or from a forged institute.
आप हमको पुख्ता डॉक्यूमेंट दीजिए ऑफ योर डिपार्टमेंट ऑफ योर सर्कुलर एंड व्हाटएवर सर्कुलर इंटरनेट से डाउनलोड करके मत दीजिए. दैट वी विल नॉट हियर. अगर है तो दे दीजिए, नहीं तो कंटेंट फेस करिए, नहीं तो ऑर्डर सेटिस्फाई. 3 ही ऑप्शन आपके पास है. कोई चौथा ऑप्शन नहीं है. इंटरनेट से किसी भी इंस्टीट्यूशन का कोई भी एक डॉक्यूमेंट लगा के यहाँ पर क्या बोल रहे हैं. यस, थोड़ा सोच के देखिए. थोड़ा ना स्टेट का इश्यूज से हट के सोच के देखिए. चौकीदार के लिए क्लास 10 का सर्टिफिकेट ओपन यूनिवर्सिटी से नहीं होना चाहिए, तो आपका डोमिसाइल का कहानी खत्म हो गया ना. सुप्रीम कोर्ट का नया जजमेंट आ गया. आई डोंट नो जजमेंट आया है कि जस्ट आ गया ना, दैट इंडिया डजंट हैव अ कॉन्सेप्ट ऑफ डोमिसाइल. एवरीबॉडी इज अ डोमिसाइल ऑफ इंडिया. पढ़े कि नहीं जजमेंट?
नहीं.
तो लगता है हम देखें. जब तक मेरे हाथ में जजमेंट नहीं होगा तब तक हम कुछ ऐसा बोलना नहीं चाहते. लेकिन आई थिंक देयर इज अ जजमेंट टू दैट इफेक्ट. या हो सकता है कि आजकल तो कुछ भी कोर्ट में कुछ बातचीत होता है, उसमें भी कुछ कुछ रिपोर्ट कर देता है. तो आई डोंट नो वेदर इट हैज अल्टीमेटली ट्रांसलेटेड इनटू अ जजमेंट और नॉट. बट एज आई नो दैट देयर इज सम डिस्कशन ऑन दिस.
Not only domicile, in this case also, the
We
certificate
don't
is
know.
to be.
आप अपना सप्लीमेंट्री शोकॉज फाइल करिए, अपना सर्कुलर लगाइए, इंटरनेट से डाउनलोड करके कोई डॉक्यूमेंट. प्लीज डोंट. अगर है तो लगा दीजिए, नहीं तो इनको अपॉइंटमेंट.
लगाएंगे सीबीएसई का जो वो रिकॉग्नाइज्ड इंस्टीट्यूशन का जो
सीबीएसई का रिकॉग्नाइज्ड इंस्टीट्यूशन से आपको क्या लेना देना है? आप अपना सर्कुलर लगाइए कि क्लास 10 को हम नहीं देंगे. सीबीएसई बोला है ओपन यूनिवर्सिटी में से जो पढ़ लेगा उसको 12th में एडमिशन दे देंगे. कैसा बात करते
नहीं
हैं?
नहीं, जिसको वो रिकॉग्नाइज करता है उसका एक लिस्ट सीबीएसई है, उसमें हमारा जैक भी है. वो लिस्ट भी हम अभी
आपके
निकालें.
इसमें एडवर्टाइजमेंट में है कि जो सीबीएसई जिसको रिकॉग्नाइज करेगा उसी को हम मानेंगे.
बट मतलब
Is it a condition?
सब्जेक्ट टू कंसीडरेशन कि अनरिकॉग्नाइज्ड इंस्टीट्यूट का डिग्री कैसे वैलिड होगा फॉर द पर्पस
Unrecognized
ऑफ
मतलब I
अपॉइंटमेंट.
just want to know who will recognize. Who will recognize? There has to be a circular of the state government that we will recognize these institutions. इसका लिस्ट में जो होगा उसको करेंगे, बाकी लोग को नहीं करेंगे. और अगर ऐसा सर्कुलर नहीं है तो फिर आप कैसे इस तरह से कर सकते हैं? You have to bring your circular. You can't be like this. Just one minute.
We'll seek instruction from the department itself.
अच्छे से समझ के फाइल करिएगा.
इंस्ट्रक्शन में
समझ के इंस्ट्रक्शन लेकर एफिडेविट भी समझ के फाइल करिए. कंटेंट सिविल 1087 of 2020. The learned counsel for the opposite party submits that the matriculation certificate
here मतलब
Yes.
matriculation certificate issued by Open University is not recognized.
मतलब ऑल इंडिया काउंसिल फॉर ओपन यूनिवर्सिटी.
हाँ, matriculation certificate उसी टाइम है.
हाँ, वो सर्टिफिकेट हम
हाँ,
लगाए
जी.
हैं. इसका देखना है ऑल इंडिया काउंसिल फॉर
Matriculation certificate issued by All India Council for Open Education
एजुकेशन.
is not recognized. However, no document with regard to any circular or no document by way of any circular etc. has been annexed, issued by the state government has been annexed along with the show cause to substantiate this submission. Some document has been annexed after downloading it from the internet, which is not acceptable to the student. Counsel for the opposite party placed for time to file supplementary show cause explaining the position. Post on 21st March.
Okay.
The supplementary show cause should be filed by 18th of March.
From daily list passover case item 65. CRMP 213 of 2025.
Passover for one case.
CIMP number 213 of 2025.
Passover for one case.
From supplementary list for orders with effect item 1 first appeal 87 of 2016 along with item 2.
Should this IA be filed for extension of time, preemptive time? The defect which could not be removed is to send the record to lower court in correction in the judgment and award.
IU number 1895 of 2025 in FA number 87 of 2016. The counsel for the appellant has submitted that the interlocutory application has been filed seeking extension of preemptive time to remove the defects. She submits that
It's in paragraph 4.
registry of this court has pointed out defect number 4, stating that village name of the petitioners in the certified copy of the award differs from that in the certified copy of the judgment. And both we sent to the learned court below for necessary correction. She submits that appropriate order passed. Other defects removed? Yes. She has submitted that so far as other defects are concerned, they have already been considering their posted submissions. Let the certified copy of the award as well as the judgment be sent to the concerned court for necessary correction. It is observed that this appeal will not be dismissed on account of defect number 4. आइए disposed. दोनों का सेम है.
इसमें एक ज़्यादा डिफेक्ट है, इसमें एक डिफेक्ट है.
आइए फाइल किया दोनों.
हाँ, दोनों में.
इसमें डिफेक्ट नंबर कौन सा है?
इसमें डिफेक्ट नंबर 11 है.
सेम
नहीं, ये 11 है. Sole applicant has not signed वकालतनामा, and learned counsel has not given certificate whether the executant is empowered to sign वकालतनामा. Now the वकालतनामा is not been filed by railway by us, so there is exemption in filing वकालतनामा. And at that time,
आप अपीलन कहेंगे तो कैसे नहीं फाइल करना होगा?
exemption
नहीं एग्जेम्पशन कैसे?
then fresh वकालतनामा may be filed.
हाँ हम एक्सटेंड कर देते हैं टाइम. आई नंबर 1897 of 2025. This in FA number 90 of 2016. This petition interlocutory application has been filed seeking extension of time for removal of the defects.
Defect number 11 only. Defect number 4 is for correction in the
Yes, for removal of defect number 11, and it is also submitted that so far as defect number 4 is concerned, the award and the judgment is required to be sent to the court concerned for correction. considering the aforesaid submissions, like the award and the judgment, certified copy of the award and the judgment we sent to the concerned court for correction. Defect number 4 को quote कर देंगे ना. Parentage of applicant number 3 and 4 is missing. Add the certified copy of award. It may be sent down to the learned court below for necessary correction. So far as defect number 11 is concerned, the time is extended by 4 weeks from today to remove the same. It is observed that the first appeal will not be dismissed on account of defect number 4. बाकी सब कर दी. The council has submitted that the remaining defects are removed. डेट तो कोई प्रीफिक्स डेट होगा.
डेट फिक्स था पहले से 18 का डेट फिक्स था. डिफेक्ट रिमूव होने के बाद 18 को लगता है, लेकिन अभी डिफेक्ट है इसलिए
पोस्ट ऑन मार्च 20 मार्च तक आएगा नहीं आपका. आ जाएगा शायद, पता नहीं. 20 मार्च तक नहीं आएगा आपका. 20 अप्रैल को. 20 अप्रैल तो छुट्टी है. सेकेंड ऑफ अप्रैल. हाँ, वो एक दिन का जो डिले का नोट किया CLP रेस्टोर कर दें. इनका एक ऑर्डर कौन लिया था आपको?
सीरियल
19 में डेली कौन लिया था? नीचे फ्रेश लिखा दे, उनको बोलिएगा टाइप. फाइल फाइल आने. जस्ट थोड़ा 10 मिनट. यस मिस्टर नीलेश कुमार, क्या हुआ? कैसे होगा ये?
पासवर्ड केस आइटम 65.
पहले तो बता दें कि कैपेबल हम लोग उतना नहीं. हजूर हैज सेड समथिंग अबाउट द कैपेबिलिटी ऑफ द लॉयर. हम उतने कैपेबल नहीं है कि आप लोग कोर्ट से कम्पीट कर सकें.
नहीं, मेरा ये कहना है आप उस ऑर्डर को पहले मॉडिफाई करें.
मॉडिफाई तो यहीं से ना होगा.
नहीं, यहाँ मॉडिफिकेशन थोड़ी फाइल थी. क्या
वही रिलीज, वही गलती हो गया कि रिलीज नहीं फाइल, वो रिलीज फाइल हो गया, मॉडिफिकेशन फाइल.
हाँ, मॉडिफिकेशन फाइल होगा.
बिफोर दिस कोर्ट ओनली.
नहीं, वो जो ऑर्डर चूंकि वो जज साहब रिटायर कर गए हैं, तो चीफ साहब जिसको असाइन करेंगे.
ठीक है, इसी कोर्ट वाले इस कोर्ट में डज नॉट मीन
हाँ,
कि ये
नहीं,
पार्टिकुलर.
क्योंकि वो लग रहा है कि थोड़ा सा कुछ एरर हो गया है, या फिर मान लीजिए उनकी नजर से चूक गया है, या कुछ तो ऐसा हो गया.
एरर ऑन द पार्ट ऑफ कोर्ट ही नहीं.
सर्टेनली.
तो हम लोग सीआरपी फाइल करेंगे, इंस्टेड ऑफ रिलीज हम मॉडिफिकेशन फाइल करेंगे.
हाँ, आप एक मॉडिफिकेशन फाइल करिए, इसको हम पेंडिंग रख देते हैं, और उसके बाद जब वो मॉडिफाई हो जाएगा तब इसमें आप सप्लीमेंट्री फाइल करेंगे, हम रिलीज का ऑर्डर करेंगे, या फिर उसी में आप रेयर कर लेंगे रिलीज के लिए.
ठीक है, तो ये पेंडिंग रहेगा. यूरोशियम में
लेकिन उसमें भी बिना नोटिस के नहीं हो पाए.
ठीक है, नोटिस होगा जो भी होना है, बट यूरोशियम में कैलिसी द ऑर्डर. 2 ऑर्डर हम दिखा रहे हैं. एक हजूर का ऑर्डर है.
हम तो देखे हैं,
एंड
हमारा
सेकंड
ऑर्डर आपको पता है.
हजूर तो कैपेबल है. हजूर बोलते कि वकील कैपेबल है, क्या कौन कैपेबल? हम कैसे बोल सकते हैं कोर्ट के बारे में?
हम क्या बोले हैं?
हजूर बोल रहे हैं सेट कि भाई कौन कितना कैपेबल है हम जानते हैं. आपके
तो
सीनियर
आपके
कितना
लिए तो अच्छा ही बोले थे.
नहीं, आप जानते हैं सरकास्टिक. ये लोग लगा सरकास्टिक.
नहीं, उन लोगों को लगने से क्या, वो हमको नहीं पता है.
बट यहाँ पे हजूर अपरेंट
देखिए,
है.
आप एक बात बताइए, कोई आपकी कैपेबिलिटी में किसी को कोई डाउट तो नहीं है.
बट ये ऑर्डर जो दिख रहा है, इस ऑर्डर पे है कि हम एक लाइन पढ़ रहे हैं. Having heard the learned counsel of the parties, noted their submission and noted that the total compensation amount deposited. So that the
डिपॉजिट करके जो भी उसको मॉडिफाई,
है,
डिपॉजिट
modify,
करके
modify.
उसको एक छोटा सा मॉडिफिकेशन करा लीजिए.
CRP फाइल.
सीआरपी फाइल करा
जी.
लीजिए. आपको अपनी कैपेबिलिटी पे डाउट हो सकता है, हमको आपकी
नहीं,
कैपेबिलिटी
ऐसा
में कोई डाउट नहीं है.
I know.
यू आर मतलब क्रिमिनल मैटर्स में तो यू आर सो सीजन.
यहाँ पे ये पता नहीं ये एरर कैसे हो गया. I don't know, but the client is suffering.
थोड़ा सा इसको
ठीक है.
कर लीजिए फॉर्मल. तुरंत हो ही जाएगा, इसमें
ठीक।
कुछ ऐसा दिक्कत
ठीक।
नहीं है। और अगर उसमें लिख भी देंगे कि ये मॉडिफिकेशन यहाँ पेंडिंग है, तो हो सकता है चीफ साहब यही भेज दें तो
ठीक है,
कर
ठीक
देंगे
है,
उसको,
ठीक।
ठीक है। और अगर उनसे दोस्ती हो ही गई है, आपके जो अपोजिट पार्टी है, जबान 38 का केस है ना, तो उनको भी लेते ही आइएगा, वकालतनामा साथ ही साथ हो जाएगा।
ठीक है, हम इन्फॉर्म कर देंगे।
ठीक
बट आई एम श्योर कि दे विल ट्राई टू टेक एडवांटेज ऑफ दिस वन।
है, वो ऐसा कोर्ट के सामने कोई एडवांटेज नहीं ले सकता,
ठीक है,
कि चूंकि पहला ऑर्डर मैंने किया था, इसलिए हमको पता है कि कैसे
ठीक है।
क्या ऑर्डर था। CRMP number 213 of 2025. Also for the parties are present. At the request of the petitioner, post this case on बताइए कब?
आफ्टर 3 वीक्स ऑल्सो बिल्डिंग विल
28 मार्च को, ठीक है, 28 मार्च। इतना आप एप्रीहेंसिव क्यों?
दे आर द जूनियर्स ना, इन लोगों को लगा कि पता नहीं क्या बात है। सॉरी।
हम इनको ये बोले, पिछली बार भी यही बात हम बोले थे, और आज आप फिर खड़ा होकर वही बात क्यों बोल रहे हैं? असल में YouTube की वजह से लोग थोड़े कॉन्शियस हो गए कि कौन लिटिगेंट क्या देखेगा, क्या सोचेगा, यही सब चल रहा है नहीं?
From supplementary list for hearing under order 41 rule 11 item 8 second appeal 177 of 2023.
May I please?
अभी तो सब्सटैंशियल क्वेश्चन आप लॉ के लिए,
Yes, ma'am.
अभी तो बना नहीं है ना, फिर
May I please?
यू आर द
Let me plaintiff. Plaintiff suit was decreed and appeal filed by them was allowed. This is the specific case of the plaintiff that they purchased the suit property from the recorded tenants. Now, this is the admitted case of the defendant. Their case is that this property, suit land, 3 decimal, was transferred by oral gift. Now, subsequently, son of the vendor of my vendor has transferred the suit property subsequently in the year 2005 to the defendants. So, the learned trial court decreed my suit considering this fact that oral transfer cannot be is not permitted, and moreover my sale deed of the earlier
trial.
yes section 48 my lord is the learned appellate court what has done my lord on the basis that in the Kabdewari, name of one of the summons how is written, made out a third case, held that there was no issue of partition, held that there was a partition only on the basis that this was the recorded in the name of possession is shown as a Kabdewari possession in the name of so and so. So it was the property of summons of. So plaintiff has no title. And no issue was framed regarding that. Law is also very much clear. Since my lord, 84 of the 84 judgment, I have brought the judgment also, my lord, that entries in the revenue record regarding possession of a particular plot never infers partition. There was no issue of partition in fact. So, my lord, the learned, there is a perversity of the judgment passed by the learned appellate court. My lord will see the findings, paragraph 12 of the learned first appellate court.
So, which is your substantial?
My lord, my substantial question of law is 3, my lord. Neither Roman 2 and 3, my lord. Because this was not the case of the parties that there was partition or not partition. Rather, defendant's case, they have purchased the suit property jointly by some of the legal heirs of the recorded tenant. My case is also there, my lord. Page number 4, substantial number question 2 and 3.
Page number 4 of memo.
मतलब yes, other एक separately करके लिखा हुआ है मतलब substantial question of law after memo of parties in the grounds मतलब page number 4.
Page number 4.
Yes, madam. So Roman 2 and 3.
Who is this Soman Shah?
Summons of one of the recorded tenant.
You are the
Yes,
descendants.
one of
Your vendors are the descendants.
नहीं मेरे vendor तो joint names vendor recorded. There are several recorded tenants. My vendor was one of them. Summons of is also one of them.
Okay.
I have purchased by virtue of registered deed. They defendants made a case that summons of orally transferred the lands, and thereafter in the year 2005, defendants sale deed is of the year 2005. They purchased the property from son of the vendor of the plaintiffs.
The learned counsel for the appellant has submitted that only 3 decimal of land is involved in the present case. Correct?
Madam.
He submits that the plaintiff was claiming title by virtue of registered deed On the other hand, the dependent was claiming title by virtue of oral gift followed by subsequent sale deed, a subsequent gift deed,
Subsequent sale deed.
subsequent sale deed. He submits that the deed of the defendant was latter in point of time.
Of the year 1977.
Need not be there. उतना लिखने का जरूरत नहीं है.
Ma'am.
Latter in point of time. They have stated that the suit was decreed in favor of the plaintiff, but the learned appellate court has reversed the decree primarily on the basis of 2 points. That there was no partition.
There was no partition. There was no issue.
Reason क्या?
Yeah, reason. There was a partition.
There was a partition.
There was partition.
By observing that there was a partition between the recorded tenants and that the recorded tenant, namely Soman Sao, was in exclusive possession of the property. He submits that the appellate court has reversed the decree on the basis of findings which are not based on the case of the respective parties. He has referred to substantiation of law number 2 and 3. Two, 3 and 4.
Well,
2, 3 and 4. Which are as follows. इसको quote कर देंगे. Page number 4. Considering the submissions, this second appeal will be heard on the aforesaid substantial questions of law. Issue notice to the respondents for which requisite under ordinary process be filed by the appellant within a period of 1 week. Let the records be called for from the concerned court. Post this case on 3rd of April, awaiting service report and the records from the concerned court.
deeply aware.
Let this order be communicated to us.
Deeply.
आप जो बोले हैं हम लिखाएंगे.
हम जो बोले रिकॉर्ड से बोले.
इसीलिए ऐसा हमारा ट्रस्ट है कि आप
नहीं.
ठीक ही बताएंगे.
From daily list for final disclosure item 1, WPC.
आ गया भाई. बोलो बैठ.
एक मिनट.
एक
Item 19 from daily list.
CMT number 912 of 2024 with IA number 10618 of 2024. The learned counsel for the petitioner has submitted that the interlocutory application has been filed for delay of 1 day in filing the CMT for restoration. Counsel for the opposite parties has no serious objection to the prayer for restoration. Accordingly, for prayer for combination of delay, accordingly, IA number 10618 of 2024 is allowed and the delay is done. With the consent of the parties, CMP number 912 of 2024 is taken on notice. The learned counsel for the petitioner this petition has been filed for restoration of MA number 172 of 2023, which schools stood dismissed for on account of non-removal of defects.
Yes.
Non-removal of defects in terms of order dated 22/7/2024. reason? The learned counsel has,
Court fees was missing.
the learned counsel for the petitioner has submitted that the court fees was wrongly calculated by the counsel for the petition, and which ultimately led to dismissal of the
Email.
miscellaneous application. The learned counsel for the respondent has no serious objection to the fair for restoration. After hearing the counsel for the parties and being satisfied with the cause shown, the order the time for removal of defects granted by the order dated 22nd of July 2024 in MA number 172 of 2023 is extended till 7th of March.
Defect has been removed.
जो भी आप अपना देख लीजिएगा. Extended till 7th of March. Office is directed to, if the defects are removed within the said time, office is directed to place this case before appropriate bench as follows. Place the MA. आप ठीक से चेक कर लेंगे क्योंकि डिसमिसल होने के बाद क्या कोर्ट फीस आप फाइल किए हैं इसका कोई रेलेवेंस नहीं.
Actually, I have filed the court fees of 250 rupees and deficit in the court fees, and I have deposited it 1 day after the time.
वो आप ऑफिस से चेक कर लेंगे, ऐसा नहीं कि फिर से डिसमिस हो जाए. यू शुड बी मोर केयरफुल.
Okay, I'll check.
ऑफिस में जाके पता कर लेंगे.
Okay.
From date list for final result item 1, this is there was 6/8 of 2015 along with item 2 and 3.
आप भी टाइम मांगे, आपको भी टाइम चाहिए, सबको टाइम चाहिए.
And for the private respondent and petitioner in serial 2 and 3, which I am also trying to find.
जॉइंट वेंचर. आपने क्यों नहीं रिटन सबमिशंस फाइल किए? आपने
एक में हम 2 में हम लोग रेस्पोंडेंट हैं.
हम नहीं जानते, रिटन सबमिशंस नहीं आया,
हम चेक करिए.
कुछ पता ही नहीं है.
In this case, Mr. Suben Verma has to value this case also. He is out of business.
पिछली बार आपके नाम पे टाइम,
हम भी किए थे पर वो आज है
इस
नहीं.
बार उनके नाम पे टाइम.
नहीं वो आज आए नहीं है और फाइल भी उन्हीं के पास है.
नहीं हम भी
पिछली
हैं. बार आपके लिए टाइम हुआ था कि आप नहीं हैं, आज आप उनके लिए टाइम मांग रहे हैं कि वो नहीं है.
नहीं बहस तो हम ही करेंगे, हमारा फाइल भी उन्हीं के पास है.
फाइल लेके घूमने चले गए हैं.
हमने गलती से हमको दिए नहीं है, बाहर चले गए.
आपका एनरोलमेंट कब हुआ?
2001 में.
2001 में ना.
जी.
SAR केस 85-86 का. आपका जन्म हो गया था तब तक? बताइए.
नहीं हम लोग कर लेंगे नेक्स्ट वीक. 2 सप्ताह के बाद रख दिए हम लोग कर देंगे.
अगली बार टाइम मांगेंगे ना 50-50 हजार जिसका सर्कुलेशन आएगा उसको 50,000 रुपीज कॉस्ट के साथ हम एडजस्ट करेंगे. हम आपको बता दे रहे हैं, भूलेंगे नहीं हम इस बार. डेट बताइए कौन सी.
2 सप्ताह के बाद मुझे कुछ जोड़.
नहीं हमको तो रोज डेट है, आप बताइए आपको कौन सा डेट. आप लोग बिजी लोग हैं, हमारे पास काम ही क्या है. बताइए.
5th or 6th March.
फ्राइडे को नहीं रहेगा.
फ्राइडे
नहीं ये तो डेट है ना, फ्राइडे को नहीं रहेगा.
फ्राइडे 7th of March.
All the councils involved in this case are seeking adjournment. List of date, short synopsis, ये सब नहीं फाइल हुआ.
फाइल कर देंगे लोग.
It further acquiesces that order dated 16/12/2024, whereby the parties were directed to file list of date, short synopsis of argument and the judgments which they seek to rely upon have not been filed. At the joint request of the council for the parties, the matter is adjourned and is directed to be posted on 6th March would be better. Friday को नहीं करना,
जी
दिक्कत नहीं है ना? ब्याह शादी सब, यदि शादी में जाना है इधर उधर कुछ नहीं.
add to 15 notes
6th of March 25 to be taken up at 15.
हम लोग
The council for the parties have undertaken that they would not circulate any adjournments.
इसमें
And
written argument हम लोग फाइल कर चुके हैं notes
ऑफिस नोट बता रहा है नहीं फाइल किए हमने जाना.
ठीक
नहीं ऑफिस नोट नहीं है.
ठीक नहीं है फाइल कर देंगे
The order dated 16/12/24 we complied at least 1 week prior to the next date. हमको एक हफ्ता लगेगा पढ़ने में.
तो दूर को ज़्यादा टाइम लगेगा
एक हफ्ता. I'll take 1 week to study.
नहीं तुरंत छोटा सा मैटर है तुरंत आप ऑर्डर कर दीजिएगा
छोटा सा मैटर कोई नहीं है. CNT का कोई भी मैटर छोटा मैटर नहीं है.
वो तो है कोई भी मैटर छोटा नहीं है
Item 4, WPC 4007 of 2020.
एक ट्राइबल का झोपड़ी जो है ना, किसी के महल से भी ज्यादा नहीं. आपको भी टाइम चाहिए. क्या है?
Mr. Ajit Kumar bin Laden,
क्या हो गया?
out of station. दो तीन बार पायलट सुन चुके हैं.
स्टेट तो डिसमिस हो चुका है. आप प्रोसीड करिए. इसमें क्या करना है? दे आर नॉट इंटरेस्टेड.
नेक्स्ट डेट फिक्स की थी इसलिए नेक्स्ट डेट फिक्स कर रही थी इसलिए
हाँ तो
उस
इसीलिए
दिन
ना.
उस दिन हियरिंग नहीं हो पाया.
नहीं अब नहीं हो पा रहा है. पिछले और 2 डेट से आप लोग टाइम ले.
नहीं अभी तो एक दिन में दो आइटम नंबर 2 लगा हुआ था टेकअप ही नहीं हो पाया. हम तो 4:40 में करे थे. लास्ट डेट में हम पास ओवर कराए थे क्योंकि दूसरे
पास ओवर कराइएगा तो कहाँ से टेकअप?
दूसरे कोर्ट में थे बिजी.
आज टेकअप पूरा आपके पास.
आज नहीं आ पाएगा. एक डेट कोई भी दे दे.
तो आप लोग क्या करें? What are you doing?
We were informed today. I spoke to Kushal, he informed me that we will be taking time. Because
और भी orders हुआ है ना कोई केस?
I have no knowledge, but I'll ask Vibhas sir, who has been dealing with the matters related to detail. If there are similar cases with regards to this.
Learned counsel for the petitioner seeks adjournment by submitting that this matter has to be argued by Mr. Ajit Kumar, senior advocate, who has gone out of station.
Out of station.
Who has gone out of station. He submits that the matter be posted on
Any day.
any
Not
day.
not Friday. Not
Friday he tied up with courtesy. फ्राइडे ही टाइड अप है ना,
ये साइन
किस दिन करना है?
वो भी कर दे।
7 तारीख तक वो आएंगे नहीं ना जी?
नहीं, जूनियर की शादी में गए हैं।
तो शादी तो हो ही जाएगी ना।
हाँ, 7th.
Your Lordship, my senior is not available on 7th.
Pose this case on 27th. It is made clear that
27th
no
March.
further adjournment will be granted.
27th.
Please do not circulate adjournment slip in cases where there is an order that no adjournment will be granted.
27th February.
Further.
28
27 तारीख को रखो, Thursday, to be taken up.
Also, your ladyship was discussing about the domicile judgment, your ladyship, that had been passed by the Honourable Supreme
That has been
Court.
passed.
Yes, by the end, in the end month of January, your ladyship,
I
and
saw
they have
that.
discussed Article 5, and they have held as your
That
ladyship.
you are citizen of entire India.
Yes.
There is no concept of domicile of state. The state लड़ते हैं ना कि मेरा domicile है, इनको देंगे, उनको नहीं देंगे. I think this story is now over.
Yes, and also your ladyship, with respect to education also, the writ itself was regarding the education in the admission in colleges.
हम देखें तो याद है. It's very important. It is very relevant for many aspects, for appointments, for education.
They've discussed all of those aspects. 15, 16 have also, Article 15 and 16 have also been discussed. Much obliged.
Orders verified item 5, Civil Review 67 of 2023.
I may be permitted to withdraw this, but there's only one clarification I require. What had happened here, the writ petitioner had approached this Honourable Court for demarcating in and on strength of a sale deed. I say that the property was a joint property, my co-sharer could not have executed the sale. So therefore I have instituted a suit. It's original title suit number 439 of 23. So I may permit to withdraw this single review, but this judgment may not come in my way in the suit.
Which is under review.
Yes. Because demarcation has already been conducted pursuant to this direction of this Honourable Court. Though of course, merits of title and that those were not looked into.
Suit will always be decided on its own
On
merit.
merit, but this may not come because they may take advantage of the fact that on the strength of the sale deed, they got an order of demarcation from this Honourable Court. So your ladyship had also observed that I have the petitioner before your ladyship now, Ashok Munda, in paragraph 3, your ladyship takes note of that he has objected.
This is demarcation of the
Property purchased by the writ petitioner from co-sharer of the petitioner now before your ladyship.
we don't want to make any observation because this order will certainly not come in your way. But unnecessary, why should we make any observation? This is nothing in this order.
The only apprehension is since he had approached this honorable court that he has purchased his property on basis of a sale deed, and order has been passed considering that he has purchased, and that sale deed is under challenge in the suit.
So anything, the suit will certainly be decided on its own merit.
Only that
आपके रहते कोई इस order का advantage ले
नहीं,
सकेगा?
आज
बताइए.
the litigation we come across judgments nowadays कि उसमें high court में कुछ भी रहता है तो lower court एक prejudice हो जाता है. You've seen that.
Civil review number 67 of 2020. Why is it defective?
High court. IA is pending also for ignoring defect. That he was not a party. The petitioner was not a party in the writ proceeding, so therefore the defect has been pointed out for party position.
With IA number 2061 of 2020. The learned counsel for the petitioner has submitted that the interlocutory application has been filed for ignoring the defect in connection with party position in view of the fact that the present review petition has been filed by Ashok Munda, who was not a party in the writ proceedings, being WPC number 1580 of 2023. The learned counsel has also submitted that since the petitioner was concerned with the property, therefore he filed this review petition. He has also submitted that during the pendency of review petition, during the pendency of this review petition, one title suit has been filed by the petitioner, which is pending. The learned counsel has also submitted that appropriate observation be made that the order passed in WPC number 1580 of 2023 may not have any bearing in the suit. Considering the fact that, and he has been instructed to withdraw the civil review petition so that the petitioner may pursue his remedy in the suit. Yeah. Considering the aforesaid submissions, this court is of the view that since the petitioner was not a party in WPC number 1580 of 2023, the same has no bearing so far as the petitioner is concerned, and no separate observation in that effect, to that effect is required to be made. This will suffice?
Yes.
With this, the civil review petition is dismissed as become. Are you allowed?
Sign.
Order Sanctum 8 KPS 4343 of 2012.
Yes, petitioner.
I prayed for not today.
What happened?
My senior Mr. Manoj Tandon has to argue with us.
but तो बहुत अच्छा केस है आप बहस करिए उन्होंने आपको फाइल पढ़ने को मना किया है नहीं मना किया ना पढ़े होंगे कहानी सुने स्टोरी बताइए व्हाट इज द स्टोरी ऑफ योर केस
On 1982, Sant Tulsi Das immediate college Pulamu was recognized. On 2008, the petitioner was permitted to start its teaching of a degree level standard. And on to 2010, the petitioner handed over the charge of the principal Sant Tulsi Das Immediate College to Sri Jafar Imam. On 2011, Sant Tulsi Das Immediate College was granted permanent recognition. Then on 15/4/2011, the petitioner was asked for the so cause. Then on 21/4/2011, they given the explanation of the so cause. Then 28/4/2011, again the petitioner was asked for the so cause. Then on 25/2011, Jharkhand Academic Council communicated the secretary principal of the Sant Tulsi Das Immediate College to take a step for permanent recognition. Then after 25/2011, Sri Chandrasekhar Dubey, Regional Deputy Director of Education, Pulamu, were made the member and the representative of Jharkhand Academic Council.
So what is your case?
Your Lordship,
What is your grievance?
my prayer is that the petitioner has been dismissed from the service without framing a charge, without appointing an inquiry officer to inquire into the allegation, without issuing a second so-called notice as to why the
So
petitioner.
without any procedure, you have been dismissed. Without any procedure,
Yes,
you have been dismissed.
Yes.
Are you a permanent employee? आपका एम्प्लॉयमेंट का क्या कहानी है? Where is the order of dismissal? 23/5. पढ़िए तो पेज नंबर 62. देखिए हम आपको बताते हैं रिट पिटीशन कैसे बन सकती है. जिसमें इंप्यूग्ड ऑर्डर हो सबसे पहले उसको पढ़ने पढ़िए. You were working at 2 places at a time. Is that correct?
But I'm applying for the state notes. I'm not having the copy of the counter.
आप तो इतना देर से टाइम नहीं मांगे. हमको तो लगा आप एकदम तैयार है बहस करने के लिए. आपके पास काउंटर नहीं है, हमको टाइम चाहिए.
What's the respondent number 5 is the main party notes.
Who is appearing for respond number 5? 2012 का रिट पिटीशन है. कितना साल हो गया?
More than 12 years.
अब तो एडवर्स पोजीशन हो गया इसका. हाँ? क्या ऑर्डर्स में आया है?
Yes.
ऑर्डर्स में क्यों आया है हमारे? If SR of respond number 5 has been received on this, however, SR of respond number 5 has been misplaced. The office is trying to source this. Respond number 5 नहीं आती है हमारी तरफ से. देखिए WPS number 4343 of 2012 in view of the office note. Notice upon respondent number 3
One
and 7.
counter is there, Murad, from respondent number 6.
3 and 7 is accepted as valid. However, the service report of respondent number 4 respondent number 5 is not readily traceable by the office. In view of the office note, let fresh notice be issued to respondent number 5 for which requisite under ordinary process be filed by the petitioner within the period of 1 week. The notice should accompany the entire records of this case. पूरा record के साथ fresh notice फाइल करें for respondent number 5. Was this case on 9th of April?
Item 9. WPC 4475/116.
इसमें वो आईए पैक किया गया था आईए नंबर 10 for a meeting of the meeting the name of the petition number 3.
Petition number 3.
हाँ इसमें जो लेकिन डेट सर्टिफिकेट अभी तक रिक्वायर नहीं करता है।
हाँ क्या बोल रहे हैं?
डेट सर्टिफिकेट अभी तक नहीं मिला मुझे इसमें। डेट सर्टिफिकेट के लिए टाइम दिए थे पिछले।
ऑर्डर था डेट सर्टिफिकेट लाने का।
इसमें से एक एफिडेविट करके दिए हैं ये लिस्ट नंबर 2 डेट के लिए आपने।
आपको कोई ऑब्जेक्शन है इनके नाम डिलीशन में?
वक्त कोड से प्राइवेट रिस्पोंडेंट है तो वक्त कोड के हैं प्राइवेट रिस्पोंडेंट्स भी है।
आपको कोई ऑब्जेक्शन है?
लास्ट ऑर्डर लास्ट टू ऑर्डर ऑर्डर नंबर 15 ऑर्डर नंबर 15 4/10/2024 का
WPC number 4475 of 2016. Counsel for the petitioner has submitted that the death certificate of petition number 3 could not be obtained. He seeks adjournment. आप जो एफिडेविट दिखा रहे हैं ना वो उस ऑर्डर के पहले का पोस्ट ऑन 30th प्लीज अप्रूव उसके बाद सेकंड में लेके आइए ऐसा नहीं है अपना अपीयरेंस देंगे मेमो ऑफ अपीयरेंस दीजिए
Item 10, second field 133 of 2017.
So इसी में वो सुबह टीचर स्पेक्टर दे दीजिए एज प्लेड post on next Friday.
Item 11, Civil Review 135 of 2019.
Made physiology. Well, today it has come for substitution of the deceased respondent number 4, respondent number 6 of the writ petition. Now, what happened? The writ petition was heard on 16/7/2018. On that day, we could not mark the list, and therefore it went unheard on our part. So we filed a review petition that we may be given a chance, in view of the principles of order alteram partem, we may be given a chance for hearing. Now, we filed the petition for review. In that, we have included these persons as petitioner number 2 to 6. They are wife and daughters of the deceased Dhanipan, who was respondent number 6 in the said case. And because the petitioner of the काउंटर अफिडेविट हुआ है,
क्या बोल?
उन्होंने कहा है कि इनका डेथ बाहर हुआ था, गांव के बाहर, पर हमने रिजॉइंडर दिया है कि इनका ब्यूरियल गांव में ही हुआ है और एक ही लाइन में हम लोग का घर, गांव में भी एक ही लाइन में हम लोग का घर। तो एक लाइन वाले घर में अगर
तो सब्स्टिट्यूशन में आपको कोई ऑब्जेक्शन है रिस्पोंडेंट?
जी,
सब्स्टिट्यूशन में कोई ऑब्जेक्शन है?
सब्स्टिट्यूशन हमारा कहना है, मतलब रीट पिटीशन फाइल किया गया था। रीट पिटीशन में रिस्पोंडेंट नंबर 5 and 6 both were part. They had appeared before the honorable court in the writ petition. They both had filed counter affidavit in the writ petition. Now respondent number 5 is no else, he is brother of respondent number 6. Now in my humble submission, when respondent number 5 and 6 both had appeared and one brother had died, then it was the duty of the respondent number 5 who was alive to inform the honorable court and the respondent, my lord, that he has died under 22 Rule 10A, which is a mandatory provision in my humble submission, that it is duty cast on the party to inform the honorable court as well as the party regarding the death. He did not inform. Now in my humble submission, the points which my friend is raising in this review petition, my lord, if the order judgment passed by the honorable court is apparently there is error on the face of the record, then only review can be allowed. But when there is preliminary judgment against that the appeal will lie, then review cannot be allowed. So my submission is, then when the writ petition has been disposed of, he is praying in the IA petition for pleading the legal heirs of respondent 6 in the writ petition, which has been disposed of by the honorable court after final hearing. So in the disposal,
डेट कब हुआ?
जी, डेथ हुआ है 2005 में, रीट का सुनवाई हुआ 2018 में। Order 22 Rule 10A is an enabling provision brought into the CPC later on, and I will read section 141 of the CPC, my lord.
So you see, the fact remains, whatever be the reason, किसका ड्यूटी था नहीं था, but the fact remains that in the record, in the writ record, there was a person who had already expired. Therefore, under such circumstances, the only remedy is to recall the order and rehear it. ये देखिए, ये चीज अभी डीबी में जाएगा, सुप्रीम कोर्ट जाएगा, ये घूमते रहेगा, इससे कुछ होने वाला नहीं है। हो सकता है यही ऑर्डर रिपीट हो जाए।
हाँ, हो सकता है।
Quite possible. लेकिन कोई आदमी अगर डेड हो गया, उसके रहते अगर कोई ऑर्डर हो जाए, कैसे?
Kindly see, dead person के against में order, there is difference between suit and application. Suit has been defined in my humble submission. Suit does not include an appeal or an application. This is an application filed under section 71A of the Chotlaku Tendency Act. Now, their interest was being protected by the Deputy Commissioner, in the court. Here in this case, in my humble submission, Deputy Commissioner, the state is party. He was protecting the interest of the respondent. So, there is difference between suit and an application. So he was being represented by the state. So in my humble submission, the state was heard in this case and the final order was passed by a written and speaking order. There is no illegality in the order. Even if my friend is aggrieved by the order passed by the Honorable Court, then he has got remedy of appeal. How can he pray for review of the order? There is difference between error on the face of the record and the order which had illegal order passed by the Honorable Court. There is difference. There is judgment of the apex court. I am placing for your kind consideration. Kindly see. There is clear distinction between an erroneous decision and an order apparent on an error on the face of the record. Kindly see the judgment of the apex court, 22 Supreme Court cases. Para 33 is the relevant in my humble submission of the judgment. Kindly see what I am reading. As can be seen from our exposition of law, it has been consistently held by this court in several judicial pronouncements that the court's jurisdiction of review is not the same as that of an appeal. A judgment can be open to review if there is a mistake or an error apparent on the face of the record, but an error that has to be detected by a process of reasoning cannot be described as an error apparent on the face of the record for the court to exercise its power of review. Order 47, Rule 1 CPC. In the guise of exercising powers of review, the court can correct a mistake but not substitute the view taken earlier merely because there is a possibility of taking two views in a matter. A judgment may also be open to review when any new or important matter of evidence has emerged after passing of the judgment, subject to the condition that such evidence has within the knowledge of the party seeking review or could not be produced by it when the order was made despite undertaking an exercise of due diligence. There is a clear distinction between an erroneous decision as against an error apparent on the face of the record. An erroneous decision can be corrected by a superior court. However, an error apparent on the face of the record can only be corrected by exercising review jurisdiction. This is the already settled law of the apex court in several judgment pronouncement of the apex court. So now, if Lordship may kindly see what review he is soughting. On merits, he wants to get the order passed by the Honorable Court reviewed. Can, in my ample submission, on merit, the order passed by the Honorable Court can be reviewed? अब जहां तक सवाल उठता है कि इनका पार्टी बनाने का रीट पिटिशन में ऑलरेडी दे हैड अपीयर्ड, they had filed counter affidavit. One brother was alive, right to sue or survive, and one party was representing. The entire judgment passed by the court cannot abate. And he was being represented by the state deputy commissioner.
सुनिए सर, अब आप ऑर्डर सुनिए. Civil review number 125 of 2019 with IA number 7169 of 2020. रिव्यू और ये दोनों एक साथ कर लें
जी.
आइए और रिव्यू के लिए अलग डेट चाहिए. आइए तो हम अलाउ करेंगे
For addition of the party. ठीक है, जैसा कहा जाए कोई दिक्कत नहीं. और रिव्यू पर
मतलब आपने तो दिया ही है प्रिंसिपल ऑफ रिव्यू.
जी हाँ, ठीक है. और हम जजमेंट दिखा देंगे कि कोई
यही तो प्रिंसिपल है, एकदम क्लियर कट.
हाँ जी हाँ, ठीक है.
This interlocutory application has been filed so as to permit the petitioner number 1 to 6.
2 to 6, man.
Petitioner number 2 to 6 to pursue the present review petition.
जी.
The learned counsel has submitted that the writ petition was filed way back in the year 2000. Being CWJC number 2022 of 2000, that is R, and was disposed of by order number 13 dated 16/7/2018. in the writ petition, Dhani Pahan was respondent number 6, who expired during the pendency of the writ petition in the year 2005. But this fact could not be brought to the notice of this court, and ultimately the order in the writ petition was filed, wherein Dhani Pahan continued to be respondent number 6. The learned counsel submits that it was the duty of the writ petitioner to take appropriate steps for substitution of deceased Dhani Pahan, but no such step was taken.
He failed to inform the learned counsel.
But no such step was taken, and apparently he failed to inform the learned counsel, and consequently the order was passed. He submits that the fact remains that Dhani Pahan, a deceased, is a party in the final order dated 16/8/2018, passed in CWJC number 2022 of 2018 R, which is the
And
subject
two.
matter of review
Minor,
in the present case.
Annexure 2 is at page 19. That is the my lord's
Just
order.
on the learned counsel submits that the petitioner number 2 to 6 may be permitted to pursue the present petition, this
Minor.
review petition, along with petitioner number 1. He has also submitted that it would be sufficient if the order of the writ court is recalled and the matter of writ court be placed for fresh hearing. The learned counsel has also submitted that if the order of the writ court is recalled, the petitioners would take appropriate steps suo moto in the writ petition, so that the petitioner are substituted in the writ reference. यही आपका total case. The learned counsel appearing on behalf of the opposite party, private opposite party, has opposed the prayer and has submitted that as per the provisions of Order 1, Rule 10, what's the Order 22?
Order 22, Order 22,
Order 22, Rule 10A.
A capital.
10 capital
अब मेरा
A.
कहना है कि
Just a moment, sir, please. Order 22, Rule capital 10A. It was the duty of at least the brother of Dhani Pahan,
Who had appeared and filed
6,
counter affidavit.
respondent number 6 in the
Both had filed counter affidavit.
writ petition to inform this court about death of Dhani Pahan, so that the petitioner could have taken appropriate steps for substitution. That having not been done, the fault lies at the end of Chamu Pahan, within bracket, respondent number 5 in the writ record, and petitioner number 1 in this writ petition. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2022, bracket 417 SCC 255, and has submitted that the scope of review has been duly discussed in paragraph number 33 of the judgment, and has submitted that the grounds in the review petition are apparently of the nature of appeal. However, it is not in dispute that Dhani Pahan had expired while the writ petition was pending. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that petitioner number 2 to 6 were not party in the writ proceedings, and their predecessor in interest Dhani Pahan was respondent number 6, who expired during the pendency of the writ petition. But for one reason or the other, he could not be substituted. The writ petitioner is blaming respondent number 5, and so far as petitioner number 2 to 6 are concerned, they have no role to play. The fact also remains that the petition of 2000 was disposed of in the year 2018. In view of the aforesaid facts and circumstances, the IA number 7169 of 2022 is hereby allowed, and petitioner number 2 to 6 are permitted to pursue the present civil review application. इसके बाद लिखिए civil review application. In view of the fact that the respondent number 6 in the writ petition had expired on the date of disposal of the writ petition, and the fact remains that the order passed in writ petition has a direct bearing on the rights of the legal heirs of Dhani Pahan. This court is of the considered view that Dhani Pahan, having not been substituted in the writ proceedings, the order passed in writ petition is required to be recalled. The writ petition is to be restored to its file so that fresh order be passed in the writ petition upon substitution of respondent number 6 in the writ record, that is Dhani. The review petition, this order is being passed solely on account of the reason that the order in the writ court has been passed against a dead person. Consequently, the order dated 16/8/2018.
May I agree with you?
एक सेकंड, मुझे ऑर्डर कंप्लीट करना है. The counsel for the petitioners,
review petitioners
has undertaken before this court that they will themselves take steps
Yes, madam.
for the purposes of substitution of respondent number 6 in the writ record once the writ petition is restored. And they shall do the needful within a period of 1 month. From 1 month. Accordingly, the order dated 16/7/2018 passed in CWTC number 2022 of 2000 (R) is hereby recalled, and the petition is directed to be listed before appropriate bench as the list.
May I agree with you? My Lord, reviewing the order, recalling the order, in my humble submission on that point, actually, Lordship said that with regard to addition of the party, Lordship passing order. Now, with regard to recall,
आपने रिव्यू अभी आपसे पूछा, रिव्यू पर भी यही जजमेंट आपने दिया है?
रिव्यू के लिए जो है, माने apparently अगर error on the face of the record,
It is not an apparent error of किसी dead person के against में कोई order हो जाएगा तो उसका क्या होगा? आपके लिए वो order non executable है.
my submission is My
अब यही
submission,
है भैया ऑर्डर
my submission is the suit and application. The distinction between suit and application. Suit has been defined under section 2L of the Limitation Act. Now, what is the meaning of suit? On that point, in my humble
सर
submission,
हम आप ऑर्डर कर दिए हैं इफ यू आर एग्रीड बाय दिस ऑर्डर यू हैव योर रेमेडी हमको ऐसा लगता है कि किसी डेड पर्सन के अगेंस्ट में अगर ऑर्डर हो गया है तो वो उसका अगर लीगल हियर आएगा ही हैज गॉट अ राइट टू गेट द ऑर्डर रिकॉल्ड एंड रीहर्ड आप सेम ऑर्डर करा लीजिए इसमें क्या दिक्कत है
उसमें हम कोई दिक्कत नहीं है। my
तो
lord,
फिर
मैं-
ऐसा ऑर्डर हम यहाँ पे नहीं रख सकते हैं 2000 का केस 2018 में टेकअप होगा हर एक का रिस्पॉन्सिबिलिटी आप टाइम मांगते हैं कि भाई हमको पता करना है ये आदमी मर गया कि जी गया 2000 में केस फाइल किया है उसके बाद इतना दिन तक ये केस पेंडिंग है आपकी तरफ से भी कोई स्टेप नहीं था उनकी तरफ से भी उनके भाई की तरफ से भी कोई स्टेप नहीं था लीगल हियर्स को हम लोग रिस्पॉन्सिबल नहीं ठहरा सकते हैं
वो रीट में अपीयर हुए, काउंटर फाइल किए,
हाँ तो किए अच्छी बात है ना
उनके लॉयर थे यहाँ पर,
हाँ
तो हम उसको कैसे जान सकते हैं? उसको उनके लॉयर का ड्यूटी बनता है ना।
आपका भी तो थोड़ा ड्यूटी बनता है पिटिशनर का
एक ही गांव में
हम जो है मर गए कैसे जानेंगे उसको?
नहीं आप कैसे नहीं पिटिशनर को
जब
सब पता होता है
उसका
कौन
भाई
मर गया,
भाई अपीयर हो रहा है, भाई को बताना चाहिए था ना।
रिव्यू पिटिशन इज अकॉर्डिंग
रिव्यू वाला पॉइंट पर जो है my lord, the order which has been passed for review, my lord, in my humble
I have
submission,
recalled it. I have not reviewed it. I have simply recalled it, and the matter has been directed to be posted for fresh hearing. It's simple सा चीज़ है और हम कुछ नहीं किए।
ठीक है।
Petition item 20, WPS 806 of 2014.
Petitioner. Nobody appears on behalf of the petitioner. Post this case on 28th of March.
Item 21, WPS 2907 of 2014.
Yes, where is the petitioner? क्या बोलना है? You have filed your required affidavit in terms of order dated 29/7/2014.
Yes, sir.
आपका क्या स्टैंड है? Why there is discrimination?
The petitioner was in the year 2008 a gradation list was prepared and he had ample opportunity that he specify the objections which were present in the gradation list. Although his name was not there, but then thereafter 2009 as subsequent gradation list was prepared. Within 30 days even in 2009 he had not filed any objection. Then after a period of 5 years, he comes up with an objection, stating that therein that my name was not in the gradation list. And in the year 2009 leadership, there were all total of 11 posts which were to be considered, and as such, and no teachers were considered against those 2009 gradational leadership. Subsequently, what has happened in leadership that this petitioner has already retired in the year 2022. Now his prayer is for consideration. His prayer is for consideration in to the petition to grade 4 graduate trained pay scale. But leadership, he has not submitted any objection, even if there was a fault on our part. But he has never submitted any objection within the specified time limit. His objection comes up after a period of 5 years. His second prayer, which is with regards to consideration to the grade 7 pay scale leadership, that cannot be given as for consideration from grade 4 to grade 7 pay scale. Rule 7 of the Bihar taken over elementary school 1993 prescribes that a petitioner, that a person has to work on grade 4 post for a period of 5 years. Now when he had not worked in the post of grade 4 pay scale leadership, we cannot grant him grade 7 pay scale.
ये डिवीजन बेंच में इसमें ऑर्डर हुआ है?
देख लेते हैं। एक और जजमेंट थी सुप्रीम कोर्ट 1221 में कि आफ्टर retrospective effect financial benefits cannot be given after retirement.
Particularly when he has not worked. अभी आए थे
24 गवर्नमेंट ऑफ वेस्ट बंगाल वर्सेस डॉक्टर अमल सत्पथी।
आप फ्रेश कॉपी निकाल लेंगे?
हम निकालेंगे।
Nobody argues on behalf of the petitioner. The learned counsel for the respondents has submitted that at the time when the gradation list was prepared, the petitioner did not raise any objection, and ultimately the gradation list was finalized. Consequently, he was not given promotion. And he never worked on the promoted post.
Yes.
The claim of promotion is not a time-bound promotion. Time-bound? Time-bound promotion?
नहीं grade 4 pay scale his but time on the leadership
The last sentence. The council has relied upon the judgment passed by the Honorable Supreme Court, passed in the case of Government of West Bengal and others versus Dr. Amal Satpathy, decided on 27th of November 2024. To submit that, the petitioner ought to have assumed the responsibilities of higher post in order to draw the corresponding pay scale. कुछ higher post तो नहीं है, खाली grade change. ये judgment आपको कैसे help करेगा? ध्यान रखने का. Since the petitioner is absent, in order to give one more chance to the petitioner, pose this case on February under the heading for final discussion. इसका कुछ नोट कुछ बना के लेके आइए. Council for the respondents has undertaken to furnish short note of argument with supporting judgments.
Item 22, WPS 4298 of 2014.
Yes, petitioner. What is it?
Your Worship, to consider the case of the petition for the appointment of the post of driver election.
दो 2014 से चल रहा है. आपको क्या बोलना? What is your comment?
Your Worship, in our contract with Your Worship, paragraph 12, page number 9, Your Worship. Petitioner has submitted the two different applications for his appointment on the post of police driver with the two different facts with the regard to his date of birth, and therefore he was allotted the two different roll number, Your Worship. And the containing date of birth before the superintendent of the police and the Garwa, thereby the two different declaration and the application found. However, in the advertisement number so and so, it is strictly mentioned that the candidate has applied specifically in the one district to which the preferred, and therefore such a contradictory fact belong to his date of birth.
WPS number 4298 of 2014. Nobody appears on behalf of the petitioner. This petition has been filed for the following relief. The Learned Counsel for the state has referred to the counter affidavit, paragraph 12, to submit that the petitioner had submitted two different applications for his appointment on the post of police driver with two different facts with regard to his date of birth, and therefore he was allotted two different roll numbers. That is roll number 639 and 107. However, the advertisement number 1 of 2010 strictly mentioned that the candidate has to apply specifically in one district to which he prefers. The Learned Counsel submits that in such circumstances, the mandamus as prayed for by the petitioner may not be granted. Yeah. No rejoinder to the counter affidavit has been filed. Considering the aforesaid stand, इसमें एक brief petition with the order filed किए हैं.
And pre-petition.
The Learned Counsel has also relied upon the judgment passed in APA number 10 of 2012, annexed to the counter affidavit. has submitted that the present case is fully covered by the judgment passing day. Considering the stand taken in the counter affidavit and the judgment passed in LPA number 10 of 2012 and other analogous cases decided on 27/6/2014. This court is of the considered view that there was no scope for the petitioner to make two applications, that too by giving different date of birth. Accordingly, this court is not inclined to issue any mandamus in this case as made for. This petition is accordingly dismissed.
Item 23 WPS 0652 of 2014.
Yes, petitioner.
This is the case of dismissal from his service because of unauthorized absence of 125 days. He was initially granted 12 days casual leave, but he never joined thereafter.
All proceedings followed.
Lordship.
What is his ground?
Lordship, he never participated, although notices has been sent to the address which is mentioned in the record.
He has been inflicted the punishment of compulsory retirement.
On 28/9/2010, he was suspended. Thereafter, notices has been served to the petitioner.
बताइए इतना बीमार था तो कैसे आता? There is no willful absence.
No, sir.
बताइए.
He also not reply the notices.
He did not because he was not well. This is his contention. Nobody appears on behalf of the petition. The learned counsel but the respondent is present. The learned counsel for the respondent has submitted that the petitioner has been dismissed from service on account of overstay. He has submitted that the petitioner neither informed the authorities regarding any illness, nor he got himself treated in any government hospital. He has also submitted that in 23 years of service, the petitioner had repeated overstaying for 15 times, which also formed a part. The case was not of simple overstay, but the case was that of repeated overstay. He has submitted that the document submitted by the petitioner at a later stage has been taken care of by the appellate authority, and the authorities have exercised sound discretion in the matter. The petitioner is not entitled for any relief from this court. Area आपका case पर since the petitioner is absent, post this case on Monday, it will be taken up by सुन के order करना है, बिना सुने order करना है.
Item 24, WPS 479 of 2015.
38 days of wastage, that's it. 1 day EA, 10 day half leave, 230 day CISF constable, appeal revision dismissed, child committed, removed from service, removal from service. He has taken plea that mentally he was ill, but the certificate which has been placed by the petition, it has been discussed in paragraph 7 and 8 of the order in to page 36. Why they are not aligned. Detailed order and appellate order also, the written order, very detailed order has been passed. Proper opportunity was given to the petitioner, no procedural penal laws.
The appeals on behalf of the petitioner. The counsel for the respondents has submitted that the petitioner was working in Central Industrial Security Force within that is CISF and has been removed from service after following all procedure. And has availed all the remedies available under the respondent available with the respondent authorities. Since the petitioner is absent, close this case on next Thursday. At the
Item 25, WPS 1294 of 2016.
Yes.
Your Lordship, this is the case of appointment on the post of police constable, Your Lordship. The petitioner in this case, Your Lordship, as per para 8 of the counter affidavit has not got minimum qualification marks, Your Lordship. Second counter affidavit filed by commandant. Also, the marks of petitioner number 2, that is Jagannath Rao, was he has secured total marks of 25 and the last selected candidate marks was 32. Your Lordship.
appears on behalf of the petitioner. This writ petition has been filed by the client. The learned counsel for the respondents has referred to the counter affidavit dated 4/7/2017 and has submitted that and has referred to paragraph 8 and 9. The learned counsel has submitted that so far as petition number 1 is concerned, he failed to secure the qualifying marks in the regional language,
Yes, Your Lordship. Regional language. The minimum qualification
which
marks
was
is 30.
30%
He secured
out
20.
of 100 marks, and he secured only 25 marks. And so far as petition number 2 is concerned, he secured 25 marks, whereas the last category selected under this category was having 32 marks. The learning council has also submitted that as per paragraph 11 of the contract affidavit, the vacancies advertised prior to the year 2014 was valid only for a period of 6 months from the date of final result published. No rejoinder has been filed to the contract affidavit filed way back on 4/7/2017. Considering the stand taken by the respondents in the contract affidavit, this court is not inclined to issue mandamus as free for investigation. It is here dismissed.
Item 26, Dolphis 1295 of 2016.
As per the last order, we have to file a specific reply to para 2 of the writ petition. I am seeking lasting notice to file the specific affidavit.
This happened in 2022. Why have you not filed it? Any explanation?
As last time, we
I
filed.
will give you last one. Give me some explanation. Order was uploaded. Otherwise also it was passed in your presence. What was there in para number 12?
Maybe the case of the petitioner is for compassionate appointment, and there is a requirement at paragraph number 12 that the petitioner who was undergoing medical treatment in CIP Ranchi without availability of the report, the medical board had given the opinion, though the medical board's report was sought for. But the report was not available, and in its absence,
Compassionate appointment में भी आप ऐसा बिहेव करेंगे कितना साल हो गए?
we have given our report on basis of the medical board that has been constituted.
That's right. But why have you not complied with the order passed way back in 2022? Did you challenge this order? So, WPS number 1295 of 2016. The learned counsel for the parties are present. On 2/8/2022. The following order was passed. This to extract that. Today, when the case is taken up, the learned counsel for the respondents pray for time to file appropriate affidavit in terms of order dated 2/8/2022. However, he has no explanation whatsoever for not filing the affidavit. He prays for how much time do you need?
1 week, 2 week, 2 week.
1 week में हो जाएगा आपका?
1 week will file it.
He prays for 1 week time to comply the order dated 2/8/2022. Have you received instructions? However, he has submitted that no instructions as such has been received so far. Considering the aforesaid submissions and the fact that there is no explanation for not complying the order dated 2/8/2022, but a response to but the affidavit is necessary for disposal of the present case. The matter is adjourned and is directed to be posted on 28th of February, subject to payment of cost of ₹10,000 by the respondent to the petition. The ₹10,000 will be remitted to the petitioner at his bank account to be furnished by the petitioner, counsel for the petitioner to the respondent. That is the next step. Cost, the cost. Compassionate appointment में cost.
We have passed the order on the basis of the medical.
That's right. Either you say that you don't want to file, you argue the case. There is no problem. If you want to argue the case without that, you do it.
It may be posted on Monday. It may be argued by.
Adjournment के लिए आपके सीनियर की जरूरत है.